During this year's tragic wildfire season, WHA worked side by side with public entities helping them to quickly recover. While the fires were still burning, we were in regular communication with task force leaders and the Oregon State Fire Marshal's Office, identifying public entities that needed assistance.
Hello and welcome to today's session. It is a view from the top: harassment claims against elected officials under SB 479. This presentation is given by Dee Rubanoff and Chandra Hatfield from PHR Labor Law. It's going to be a great and informative session today. A couple of housekeeping things. If you have any questions, please select the Q&A link at the bottom of your Zoom screen and enter your questions there. There may be something in this presentation that asks you to do that in the chat box. Well, not completely wrong. We do ask that you use the Q&A box instead. And we will address all of those questions at the end of the session, not during. And without further ado, I'd like to kick this off with Dee and Chandra. Thank you very much.
Hi, I'm Dee Rubanoff.
And I'm Chandra Hatfield.
We probably look familiar to some of you because we have been presenting at Special District's annual conference for several years now. It's been quite a year since the last annual conference, and we've all gotten better at doing things virtually, but we will miss seeing your faces and interacting with you during our presentation. Maybe next year, right?
We appreciate you being here with us virtually. We're going to be available to answer questions through chat in the chat box that can be found at the bottom of your Zoom screen. We'll also be available after the session to answer questions.
With that, welcome to A View from the Top. Oregon Senate Bill 479 was enacted in 2019. This legislation made some significant changes in Oregon's workplace harassment law, including that the law now expressly applied to elected officials. When this legislation first came out, we interpreted it to mean that elected officials could bring claims for harassment as well as have claims brought against them. Nothing we have seen since then has changed that interpretation. As we will discuss, this explicit liability for elected officials creates new issues for public employers because elected officials are not employees, and there are limits on how they can be disciplined for workplace harassment. In part one of this presentation, I'm going to be discussing how we got here and giving you the background of what led to this new legislation. It started with a complaint of sexual harassment in the Oregon legislature. So we will look at the legislature's own harassment rule as it existed back then. And we will also look at recommendations made by a group of experts who were asked to review the legislature's rule for proposed changes. In part two, Chandra is going to go over the actual provisions of Senate Bill 479, and you will be able to see how many of the work group's recommendations were incorporated. In part three, I'm going to tell you about a situation we handled for one of our clients that involved a harassment complaint between elected officials. One thing we're going to avoid today is giving specific advice on board governance issues. That's not our area of expertise, and those issues tend to be very dependent on the circumstances involved. For example, we won't be telling you what specific disciplinary actions you could legally take against an elected official in your organization. However, all of you are fortunate to have special districts as a resource for getting assistance with those questions if you need it. So as I said, the story of Senate Bill 479 begins in the Oregon legislature in 2017 when Senator Sarah Gelser, a Democratic senator, accused Senator Jeff Cruz, a Republican senator, of sexual harassment. She had made an informal complaint in 2016, and she claimed that the conduct had continued after that. The Republican caucus immediately started accusing her of having a political motivation. A couple of weeks later, another senator on the Democratic side, Elizabeth Steiner Hayward, also accused Senator Cruz of harassment, and she also claimed that she had complained in 2016 and the conduct had continued after that. As a result of these complaints, Human Resources at the legislature began meeting with other females at the Capitol who had interacted with Senator Cruz, and several of them reported unwelcome touching by him as well. Those additional persons included female legislators, female current and former staff members, an intern, and a lobbyist. The legislature, because it's a workplace, had approved a personnel rule prohibiting workplace harassment. That personnel rule expressly applied to legislators, staff members, interns, and volunteers. So you can see that the legislature was ahead of the curve as far as individuals who were covered by its harassment rule. The personnel rule did not apply to the lobbyists, who are not employees of the legislature, but the Capitol building is where they perform most of their job duties. Arguably, the most egregious conduct that was reported about Senator Cruz was from a lobbyist. The harassment rule provided a couple of different avenues for a person to report harassing conduct. First, there was an informal complaint process. The complainant had to report the conduct within 1 year. If the complainant just wanted the conduct to stop and wanted to remain anonymous, then Human Resources could resolve the complaint by giving the accused person a heads up that a complaint had been made about them so they could correct the behavior. That's what occurred in 2016 when Senator Cruz was told that 2 females had complained about unwelcome touching and that he should keep arm's length distance from females in the Capitol building. The rule also provided for a more formal complaint process. Again, the complainant had to make the complaint within a year of the conduct, and it had to be in writing. All persons, including the complainant, were required to maintain confidentiality regarding the complaint. If the complaint was against a legislator, an outside investigator had to be retained. The name of the complainant was provided to the party caucus of the accused person. The final investigation report would be submitted to a conduct committee, which was comprised of 2 Republicans and 2 Democrats. The conduct committee would hold a hearing and make recommendations for discipline to the full legislative body if the accused person was found to be responsible. Any sanctions could only be imposed by a 2/3 vote of the legislature. So consider for a moment how difficult it might be to impose sanctions if the legislative members voted along party lines. I was the outside investigator appointed to do the investigation. As you see here, I found that Senator Cruz had engaged in a pattern of unwelcome physical contact with numerous female individuals who worked at the Capitol. The disciplinary process was never triggered because Senator Cruz resigned shortly after my report became public. While I was conducting my investigation, the leaders of the Senate and the House made a request to have the workplace harassment rule reviewed by the Oregon Law Commission. The Oregon Law Commission appointed a work group of individuals with expertise regarding workplace harassment issues and legislative processes. I'm going to go over some of the recommendations that were made, and you can see later what was actually incorporated into the new law. So first, there was a recommendation for the legislature to form an equity office to investigate harassment complaints. The persons in the equity office would be employed full-time by the legislature, but they would also be neutral and independent. The obvious purpose was to prevent elected officials and other persons in power from having influence over the outcome of the harassment complaints. Having this kind of independent internal office is probably not going to be feasible for most of your organizations, but this does emphasize the need for a process that is neutral and independent, and in most cases, this will require an outside investigator who is experienced in handling harassment investigations. The work group made recommendations about what should be included in training, which is not addressed specifically in Senate Bill 479, so it's a good idea to take a look at that here. There was a definite preference for interactive training, which can be online, but something other than a pre-recorded video that gives no opportunity for interaction. The work group wanted accountability to ensure that elected officials participated in the training. So they recommended that legislator participation be documented and those documents made available to the public. There was an emphasis on training regarding consensual relationships and that consent can be withdrawn. And the work group felt that the training should encourage bystanders to intervene if they witnessed harassment in the workplace. The work group made a point of recommending some safeguards for interns and volunteers, arguably the most vulnerable workers at the Capitol. This came up because it was discovered in my investigation that the party caucuses had a practice of bringing in interns and assigning them to work with legislators without the knowledge of human resources. And in fact, 2 interns who ended up reporting unwelcome touching by Senator Cruz had been assigned to Senator Cruz to work in his office after the informal complaints were made against him in 2016, and human resources had no knowledge of that. So you should be thinking about this for your organization if you have interns or volunteers and tracking them at the beginning and end of their service. There was a suggestion from the work group that complaints against legislators should have to be under penalty of perjury. The reason was to prevent complaints from being made in bad faith for political purposes. There was a suggestion, a recommendation for no time limit on making a complaint. The work group also recommended that the conduct committee would decide if the harassment policy was violated. Would your organization have a conduct committee, or would the board make this decision about whether harassment had occurred? What if you did not have a majority vote? Regarding disciplinary sanctions, the work group recommended that the conduct committee could impose discipline other than censure or expulsion, which would have to be done by the legislative body, and that expulsion should require a 2/3 vote of the legislative body. Expulsion most likely would not be an option in your organization for an elected official. The work group proposed other possible sanctions, and some of these may not be feasible for your organization either. I've listed them here. As we discussed earlier, you should get advice from a board governance attorney regarding lawful sanctions that could be imposed in your organization. The legislature's harassment rule defined protected classes as sex, race, national origin, disability, age, religion, marital status, and sexual orientation. The work group recommended broadening the protected classes under the harassment rule to include those listed here: engaging in whistleblowing, opposing unlawful conduct, taking protected leaves, and injured worker status. Chandra is going to talk about Senate Bill 479 now, and you can see if any of these additional protected classes made it into the new harassment law. If any of you would like to get a copy of the Oregon Law Commission Work Group's recommendations, let us know, and we'd be happy to send it to you. We'll be right back with part 2 of our presentation.
The legislative process Dee mentioned actually resulted in 3 significant new laws related to workplace harassment. I'm going to talk about all 3 and what they do, but where I'm going to spend most of my time today is on Senate Bill 479. The bill was sponsored by one of the complainants Dee mentioned earlier, Sarah Gelser. It's targeted at public employers and makes several big changes to the harassment laws. Those include that employers must now have written policies and procedures related to workplace harassment, that confidentiality, non-disparagement, and no rehire provisions are significantly restricted, and in some cases they're prohibited, and that the statute of limitations for harassment complaints changed from 1 year to 5 years for conduct that occurs on or after September 29th of 2019. One thing to keep in mind about the new law is that it does not change the types of conduct that are unlawful. Instead, according to a news release from the Oregon Senate Majority Office in April of 2019, what it does and is intended to do is to make it easier to get information about the employer's workplace policies and procedures. It's also intended to make it easier to get information about non-discrimination laws themselves and the remedies that are available to victims. And it's also intended to ensure that elected officials, such as elected board members, are held accountable for their conduct. So what is workplace harassment under the law? Like I said, it's conduct that is already prohibited by existing statutes. And this includes, for example, discrimination and harassment based on race or color or national origin, gender, sex, sexual orientation, gender identity, age, disability, marital status, religion, and military or uniformed services. You can find more information on protected status on the Bureau of Labor and Industries website, which is linked in the materials. And the Bureau of Labor and Industries is also referenced as BOLI. When we're talking about harassment, we're talking about unwelcome conduct of a protected status nature. Again, race, gender, age, disability, the things that we were just talking about, that is directed at the person because of that status, and the person's submission to the conduct is either a condition of employment or their submission or rejection of the conduct is a basis for an employment decision. It also includes unwelcome conduct of a protected status nature where the conduct is sufficiently severe and pervasive that it has the purpose or effect of creating a hostile work environment or unreasonably interfering with the person's work. That's the test that most folks are going to be familiar with: hostile work environment harassment. Senate Bill 479 also makes it clear that retaliation has to be prohibited by employers. Retaliation is also a form of unlawful discrimination, and it includes adverse action that's taken because the person complained about harassment, cooperated in an investigation, whether that's an internal employer investigation or an outside investigation, such as one conducted by BOLI, or the person otherwise assisted in enforcing the employer's policies. Retaliation is really broad, and it can be on or off duty. It can be employment related or not employment related. If it would discourage a person from reporting violations or cooperating with investigations. So let's talk about the requirements for employers to implement written workplace harassment policies. Even though most employers already had harassment policies before this law went into effect, Senate Bill 479 now requires those policies to be in place and adds very specific information that has to be included in those policies. For example, the policy must now include the scope of individuals who are covered. And in addition to employees, the law expressly adds coverage for volunteers, interns, and importantly, elected officials. This includes elected board members for districts. Now I'm going to touch very briefly on board members who may be appointed. It's not currently clear whether or how the law would apply to any appointed board members as opposed to those who have been elected. This might depend on the way the appointment is structured, including whether there's any compensation to the person who's appointed. As Dee mentioned, we recommend that you work with special districts for board governance and structure issues. One thing I will say, however, is that the Oregon Bureau of Labor and Industries was very aggressive in pursuing the issues that came up in the legislature before the law went into effect. I would be surprised if they were not equally aggressive in trying to prevent appointed board members from creating a loophole in the law and engaging in conduct that is otherwise prohibited merely because their position has been appointed rather than elected. But at this point, we don't know the answer to that. Another significant change in the new law is that it also restricts the use of confidentiality and non-disparagement agreements that limit discussions of incidents of workplace harassment. So victims have the right and have to be told that they have the right to talk about incidents of harassment. This can create very difficult and uncomfortable situations in the workplace, particularly when the person being accused denies the allegation or feels like they're being wrongly accused and unfairly harmed by the public discussion. Even in those circumstances, the law requires that the individual has the right to talk about the allegations of harassment. And not only do we have to tell the victims that they have the right to disclose incidents of harassment, but the law prohibits employers from requiring the person to enter into a confidentiality or non-disparagement agreement related to incidents of harassment or alleged harassment. A confidentiality provision or non-disparagement provision or a no rehire provision, which I'll come back to, can only be included in an agreement if the victim or the alleged victim voluntarily requests the provisions. Now, this doesn't mean that the employer has to give a separation or settlement agreement or agree to anything. But if you're going to enter into one of those agreements, this is the only way to get these provisions. And you still can't include it if it involves an elected official, which I'm going to talk about more in a little bit. This interactions and future claims and claims of retaliation, regardless of whether there was any unlawful conduct in the first place. Without these provisions, we have individuals who either to provide information about claims. In our practice, we find that employers don't usually want to give employees a roadmap to make claims against them. This seems pretty common sense. Even where a person's rights have not been violated, the claims process is costly and it's time consuming for employers. But under Senate Bill 479, that's pretty much what employers have to do. Employers must expressly notify covered individuals of their right to bring claims, including with the BOLI and the BOLI process and in court. We have to tell them how long they have to make the claims, what the statute of limitations is, and the requirements for any tort claims notices. We also have to tell covered individuals what remedies they can get, like reinstatement, back pay, front pay, emotional distress damages, attorney's fees, and how they can find resources. So how they can find a lawyer or get other support like counseling. This has impacts both for the employer as an entity, but also for individuals, including board members. So not only are claims allowed against the employer, but Oregon law provides for claims against individuals who aid and abet unlawful harassment or effectively facilitate or make unlawful harassment possible. Depending on the role of the board in the workplace, as well as individual board members' conduct, this could make individual claims more likely as well. I've included a couple of slides here outlining the procedural requirements that must be included in policies under Senate Bill 479. These are really best practice procedures that have now been made explicit requirements under the statute. For example, it must be clear how long covered individuals have to make a complaint, including an internal complaint. The minimum amount of time that has to be provided is either 4 years from the date of the incident or the statutory limitations period, whichever is longer. Since the statute of limitations is now 5 years under Oregon law, that's going to be the longer period of time as a general rule. Either way, one thing to consider is that employers may not want to set any limitation on the time during which a person can make an internal complaint. This puts you in the best position to address and stop conduct before it gets to the point of liability, before outside claims are made. And it also shows everyone in the workplace that the employer takes its obligations and expectations related to workplace harassment very seriously, regardless of the passage of time. The new law also includes an express requirement to follow up with victims of alleged harassment at least once every 3 months for a year. This is another one of those best practices that employers were hopefully doing even before Senate Bill 479 went into effect. In a lot of cases, it is appropriate to follow up more frequently even than once every 3 months. This really provides an advantage to employers because it gives the employer the opportunity to make sure that if there's any bad or inappropriate conduct that's occurred, that it is actually stopped, and that regardless of whether inappropriate conduct has occurred, that there is no retaliation occurring in the workplace. It also gives the employer the opportunity to connect with the complaining employee and help build back any trust that needs to be built back. Like I mentioned at the beginning of this section, one of the goals stated by the Senate with Senate Bill 479 was to increase knowledge of employer policies. And the way that they did this in the law was to require that employers give all new covered individuals a copy of the policy upon hire. It also requires that individuals who raise concerns about harassment have to be given a copy of the policy at the time they raise the concern. And this doesn't necessarily require a formal complaint. The obligation is triggered whenever a concern about harassment is raised. So the person could be making a more general inquiry or statement or saying something along the lines of this happened and it was really uncomfortable. And that could be enough to trigger the obligation to give a copy of the policy and put the individual on notice of their rights. Obviously, this is important for managers and supervisors to know. But if your district allows for reports to board members, and a lot of smaller districts do, the obligation is going to apply to the board members as well. So it's really important to make sure that both supervisors, managers, and all board members understand the obligation and the process that's been set up by their district. There are some concurrent obligations that I want to talk about with respect to public employees in particular, and that's the public employee whistleblower statutes. On top of the requirements of Senate Bill 479, another thing to keep in mind is that if the complainant is an employee, the complaint may be covered by the whistleblower protection laws because those laws protect reports of legal violations, which include harassment complaints. Now, the whistleblower statute only applies to whistleblowers who are employees, so it's not applicable if the complainant is an elected official, but the anti-retaliation provisions of the non-discrimination laws would still apply. The whistleblower protections are significant in this context because they require that the identity of the complainant be kept confidential. While it's not always possible to prevent people from making assumptions or figuring out who filed a complaint, particularly in smaller workplaces, it is an obligation on the part of the employer not to disclose the identity of that individual while the investigation is ongoing. So doing things like merely redacting the name from a complaint might not be enough if the person can be readily identified from the context. Like I mentioned at the beginning of this section, the legislature actually passed a series of bills related to workplace harassment during the 2019 legislative session. In addition to Senate Bill 479, they also passed a more broadly applicable Senate Bill 726, which is referred to as the Workplace Fairness Act. This law applies to all employers, including public employers. We don't spend a lot of time on it or talking about it because Senate Bill 479 pretty much covers all of the same requirements as Senate Bill 726, and in fact has more obligations for public employers than 726 does. But what's important about Senate Bill 726 is its provision about contractual severance agreements. It's pretty common for us to see employment agreements between public employers and their managers that have provisions for automatic severance payments when the person leaves employment. Senate Bill 726 makes those automatic severance provisions unenforceable if the person is separated for a violation of the harassment policy. So it adds some teeth to the employer's enforcement of its policy and some extra motivation for those individuals to comply. Now, when we're talking about elected board members, we don't typically see these agreements with elected officials, so it doesn't have the same deterrent effect for this group. In those cases, the district and victims or alleged victims are going to need to rely on the other available remedies to enforce their rights. Dee is going to talk about a specific example in the next section. And like I mentioned before, special districts may be able to provide you with more information on the options and remedies that are applicable to your particular board. That being said, however, the legislature did not ignore elected officials in trying to find other ways to deter bad conduct. The last bill that I want to talk about before I turn this back over to Dee is Senate Bill 478. And this one is targeted directly at elected public officials like elected board members. It focuses on a political pressure point for people who are subject to public election, and that's publicity. What Senate Bill 478 does is it makes it unlawful to use any public funds or third-party funds like campaign funds for confidentiality and non-disparagement provisions related to harassment by an elected public official. This means that even if the complainant were to request a confidentiality and non-disparagement provision in a separation or settlement agreement, like we talked about earlier, as a public employer, we cannot include that provision if the accused is a public official and the agreement includes the use of any public funds, which most of them are going to do. So with this context, Dee is now going to talk about a real-life example that arose between elected public officials after the new law went into effect. And I'm going to turn it back over to Dee.
Thank you, Chandra. I'm going to continue now with part 3 of our presentation. This is our real-life scenario. We've had a couple of cases come up in our office involving harassment complaints against elected officials since Senate Bill 479 was enacted. In one case, the accused board member resigned before the investigation started, and the public body chose not to continue the investigation. The other matter, involving a city council, went all the way through the investigation process, and we're going to talk about that now. This was a complaint against a city councilor that arose in 2020. There were 5 voting members on the city council, the mayor, and 4 councilors. 2 councilors accused another councilor of creating a hostile environment by making comments about their age, yelling, and engaging in profanity toward them during meetings. There were a few factors that made this a particularly challenging situation. For one thing, while the investigation was going on, the mayor announced that he would not be running for re-election, and the accused person and one of the complainants both decided to run for that office. So while this wasn't a matter involving Democrats versus Republicans, like in the legislature, it did involve 2 political rivals. Another complication was that the conduct had allegedly occurred during meetings where the city attorney and the HR director were present, so they were potential witnesses and needed to be insulated from managing the complaint process. And finally, the city did not have a city manager at the time and was in the middle of a recruitment process. There was an interim city manager, and he was an applicant for the position, and the city council would be making that hiring decision. This was what we call a perfect storm. Fortunately, before the complaint was made, the city had revised its workplace harassment policy to incorporate the changes from Senate Bill 479. Also, the council had adopted an ordinance that made the harassment policy applicable to the council members. And lastly, the city council had modified its conduct rule to address disciplining a council member for violating the harassment policy. So there was at least part of a structure in place. The message here is to be prepared and get a process in place for dealing with these types of complaints before an issue arises. Let's look at what the council put in place. The first paragraph here is where they incorporated the harassment policy into the conduct rules that applied to the council members. In the paragraph below that, the rule required a unanimous vote to impose discipline and specified that the accused person could not participate in that vote. The rule did not say anything about excluding a complainant from voting in a situation where a complainant was also a member of the council. I don't know if that was an oversight or intentional. The rule also stated that the council could vote for censure or other appropriate sanctions. As we've discussed a couple of times today, other appropriate sanctions is something that requires legal advice specific to your organization. Getting back to the complaint between the councilors, it seemed clear that this was a matter that was covered by Senate Bill 479 and that the city needed to investigate the complaint. The first issue to be decided was who was going to manage the investigation process. It didn't seem like a good idea to put the interim city manager in the middle of this, especially considering that he was an applicant for the city manager position and the council would later be making that hiring decision. And as I said before, the city attorney was a potential witness. So our office stepped in as employment counsel, which made sense because we had expertise in dealing with harassment investigations. For your organization, if you didn't have an employment attorney on speed dial, your first call would probably be to special districts. Another question that had to be addressed was whether the investigation report would be covered by attorney-client privilege, at least to begin with, and we will discuss that on the next couple of slides. And there was also a question of whether the council needed to vote on some of these decisions. As the investigation progressed, there were several issues that arose regarding confidentiality. Looking at the first bullet point here, the complainant wanted to be able to discuss the complaint publicly. and other members of the council questioned whether that should be permitted. Remember what Chandra said earlier, that under Senate Bill 479, a victim of harassment is allowed to voluntarily disclose information about the harassment. And in fact, Chandra told you that your policy had to state that. Under the second bullet point, the city had received public records requests from citizens and the media. Many of the exemptions under the public records law require you to balance the public's interest in disclosure. It seemed obvious in this case that there was a public interest in the complaint, particularly because the accused person was an elected official who was currently running for the office of mayor. But each requested document had to be examined separately. For example, there was a request for the video of an executive session in which some of the conduct allegedly occurred. We determined that the video was exempt from disclosure unless the city council voted to release it voluntarily. One exemption under the public records law that is pretty clear-cut is for records covered by the attorney-client privilege. That may be one reason why you would want the investigation report to be covered by privilege, at least initially. The city council could always waive that decision later, but that decision needs to be made at the very beginning of the process with the assistance of legal counsel. In the case of the complaint against the city councilor, we decided that the investigation report would not be privileged, but that was based on some recent public criticism against the city for not being transparent with the public in connection with a lawsuit against the city. And the city council had made clear that they wanted a policy of transparency going forward. You might make a different choice for your organization. If the report is privileged, the public body would likely have to vote at some point on whether to release it. This raises the question of who would get to participate in that vote? The accused person? The complainant? I've noted here that even when an investigation report is privileged under the public records law, the privilege can be lost if your organization makes a public statement, even partially disclosing information in the report. So what happened in this case? Well, the outside investigator found that the statements by the accused counselor did constitute age discrimination and violated the city's harassment policy. The report was provided to the council before it was released to the public, and they discussed it in executive session. One thing to keep in mind is that under the public meetings law, if you're going to discuss the disciplining of a public official in executive session, the public official has the right to request that it be heard in an open session. In this case, no discipline was imposed, and the complainants seemed to mostly want the report to be published on the city's website, along with the video of the executive session in which the conduct occurred. The council voted unanimously in favor of that action. The election for mayor was held 1 month later, and the council member who was found to have engaged in age discrimination won the election by a significant percentage. There was a flurry of public commentary about the complaint and the investigation. Even though the investigation found that the counselor had violated the harassment policy, some citizens criticized the complainants and accused them of having a political motive for making the complaint. We will undoubtedly be seeing more of these situations come up in the future. What will you do to be prepared? This concludes the PowerPoint presentation portion of our presentation. Please be sure to visit the sponsors in their virtual booths, and we'll be here shortly for a question and answer session.
Well, hello again. I hope you enjoyed that presentation. It looks like we do have a number of pretty good questions out here. And I'm just going to go ahead and go on down the list. And Dee and Chandra, if you're available, there you are. Can address these as we go. The first question I have here is from Mark. It says, during the investigation of harassment, the victims do not want the suspect to know who they are or the specifics of what they reported, just general statements? Is there an ability to keep information from the victims confidential?
Chandra, you want to take that
Oh,
one?
sorry. The short answer on that is it depends. It's our favorite lawyer answer if you've ever been to any of our other presentations. The district has an obligation to do a prompt and thorough investigation. And so while we have an obligation to maintain the confidentiality of the name of the person who's complained or the identity of the person who's complained, you may not be able to maintain confidentiality of all of the factual information or allegations that have been shared with you, because you have to be able to investigate them and come to some determination about whether the alleged conduct has actually occurred or not.
I'm going to jump in because another person asked a question that was very similar under that whistleblower law that Chandra talked about, as far as, if you can't identify the name of the whistleblower, how do you ask the accused person about the allegations? And I have to deal with this sometimes when I do investigations, and I know it sounds like splitting hairs, but there's a difference between identifying who the complainant is, who made the complaint, versus who the complaint is about. And you do need to be able to ask the accused person, did you do this to this person? That doesn't mean you're identifying that person as the one who made the complaint. You wouldn't, for example, want to show the accused person the actual written complaint if you have one that has the name of the complainant there. So you just have to, kind of work your way through the process and just be careful you're not identifying who actually made the complaint.
Okay. The next question from Debbie is, the complainant is allowed to discuss the complaint. How does that impact work environment if they are sharing the allegations and gossiping with other employees before the investigation is finished and outcome determined?
Yeah, that's tough because we can't stop the individual from discussing the complaint, just like we talked about in the materials. And so it does have the potential to create that tension, that potential gossip in the workplace. Obviously, we can direct the individual from engaging in any conduct that would interfere with the investigation, but that does not mean that we can tell them not to talk about the complaint and their allegations. If there is evidence that the person is spreading false information, we want to have some pretty good evidence of that. If they're not speaking in good faith, and they're actually spreading false information, you may be able to take some action in response to that. But with respect to the ability to just tell the person not to talk about their complaint, we just don't have that ability. And that's actually a pre-existing obligation under the law that's not limited to the new Oregon law. That the Federal Equal Employment Opportunity Commission, or the EEOC, has also taken that same position for quite a long time, that employees have the right to talk about their complaints. What's new in the Oregon law is the requirement that we have to affirmatively put people on notice that they have the right to voluntarily disclose information about their complaints.
Okay. Next question. Regarding prohibition from disclosing the identity of who made the complaint, if the complainant is the person who experienced the harassment, how do you conduct interviews and ask the respondent to recall events without it being obvious who made the complaint? I think you had touched on this a little bit before too.
Yeah, so I think that follow-up question that I addressed a minute ago, and if there are more questions on that, you're welcome to reach out to us via email if you'd like more information on any of these questions that have been asked. Okay.
The next one, I'm not sure, we may need some clarification from this one. This was done anonymously. Can you go back to 726/479? You used the word unenforceable as it pertains to.
Yes. Okay. So that actually comes back to the provision in Senate Bill 726 that provides that if an employer has an employment agreement that provides for severance. So like I mentioned in the materials, many public sector employers will have employment agreements with management level folks that say, if your employment terminates for, anything other than, significant misconduct, you're automatically entitled to severance pay, or in some cases they don't have that limitation. And so those contract provisions that provide for automatic severance pay are unenforceable, and they can be voided under Senate Bill 726 if the individual is terminated for violating the harassment policy.
Okay. The next one is from Gene. He asks, our district policy defines harassment as referring to a protected status by law. Can Oregon law expand the definition of harassment as management expressing dissatisfaction with performance, or management not taking employee recommendations, or management asking if employee is complete with a task which is not completed to management expectations?
So I'm not 100% sure I understand the question, and I'll have Dee jump in as well. To the extent that the question is, can that generate a complaint? Yes, right? I mean, anytime that management takes an employment action with an employee and in particular expressing dissatisfaction with employment, that has the potential to trigger a complaint, and then you go through the investigation process. In and of itself, it is not harassment, right? Where it becomes potentially unlawful is if that expression of dissatisfaction or taking performance action is targeted based on, if there's differential treatment targeted based on protected status or activity. Like I said, I'm not quite sure that's what you're asking. If it's not, go ahead and message us separately, and I'll have Dee jump in and on anything she wants to add on that as well.
Yeah, no, I think that's correct. The new law doesn't change basically what it takes to prove harassment, and there's case law out there about the level of conduct that is necessary, and that genuine performance management is not going to be considered harassment. But then there is that, as Chandra mentioned, that can be an underlying question of what is the motive, and is the person being treated differently, and the way they're being performance managed.
That makes sense. The next question, what is the statute of limitations once a formal complaint has been initiated, internal investigation and fault determined, and complainant notified?
So I guess to me the question is, when we say a formal complaint has been initiated, the statute of limitations for filing legal action is not changed by your internal investigation, right? Some employers have, either through a collective bargaining agreement, they may have some time limits that apply to internal investigations. And so a little bit of that's going to be dependent on internal policies. But normally there's not a specific statute of limitations on when and how long it takes to do an internal investigation. The obligation is to do a prompt and thorough investigation, and how long that takes often depends on what the nature of the allegations actually are and how many witnesses are involved.
Okay, got one here from Ron Downs. What if the individual is trying to direct the investigation, and what witnesses say?
So I'll have Dee jump in on this as well, but hi, Ron. My take on that is that gets to crossing that line where the person is, if they are engaging in conduct that interferes with the investigation, as opposed to simply talking about their complaint or their experiences in the workplace. And so obviously it's going to be very situation specific, but if they are trying to dictate what other witnesses say, that's an interference issue.
Agreed.
Okay. What constitutes choosing to do an internal investigation versus an outside investigator investigating? How do you make that decision, I guess?
It depends.
Here, that is a case-by-case situation. You may be dealing with an employee who's got what's called due process rights, and the accused person, and in that case, you have to be very careful. The rules are clear that it has to be a fair and impartial investigation. And we want to do that anyway, even if the person doesn't have due process rights, right? We want to have a fair and impartial investigation. So you need to think about all the players involved. And if you have someone internally who either has a conflict of interest or somebody who might have bias, or someone, especially in the case if it's an upper level manager, your district manager, a board member who would have power over somebody like the HR manager, who might be normally might be your first choice to do that kind of internal investigation. But it's problematic to have an investigator who reports to or can be disciplined by the person who's being investigated. So if it's a board member who's being accused, you're usually going to need to bring in an outside investigator.
Okay. And our last question here from the attendees, what would happen in a situation where the one being accused of the harassment is either part of the board or a conduct committee?
So, well, I will have Dee jump in on this as well, because, in the example she gave in the materials, that's exactly what happened, right? Is that the individual being accused was part of the council. And so when we talk about what would happen, from the standpoint of doing an investigation and coming to some conclusion about what the factual findings of the conduct are, that should look, very much the same as if it's somebody who is not a member of your board or conduct committee who is being accused, right? What the consequences of that finding, assuming that somebody has engaged in inappropriate conduct or violations, the consequences of that then are going to vary depending on individual board procedures. And again, we're going to send you back to SDAO for that on the individual entity board rules and procedures and what your options are there.
Okay, and I did get some feedback that we did miss a question, but this was one submitted by Gary Brooks that asked where we are a fire district who contracts with a neighboring district for admin services. Can one of our fire board members be charged with harassing one of the other district's employees? The feedback we got from the panelists is this is a very specific situation. And to answer that fully, I believe you said that you're going to need a little bit more follow-up information. So
let me, and that's absolutely the case. And let me just say, maybe, right? It is very possible that you could end up with a claim against a board member based on that, but we would need more information.
Okay. Yeah, I'm getting the signal that we have a 3-minute wind down here. So I think this would probably be a good time to conclude this session, unless our panelists have something they'd like to add. Any last minute thoughts?
Nope.
Oh,
Nope.
Okay.
Thank
well,
you,
with
everybody.
Yeah, thank you for donating your time to be here and do this. One thing, a couple housekeeping things. Be sure to tune in at 1 o'clock for the SDAO business session. And also at 3 o'clock, there is the award ceremony. And be sure to log into the session page to fill out the your survey for this wonderful event. So again, my name's Chris. We have Dee and Chandra, and we are glad that you joined us today. Thank you very much.